and ensuring that decisions to detain are within law. Secondly, identity, health and security. Some states detain very much on the basis of concerns around security. So the US will talk about how they screen that to make an informed decision on risk. And the next is looking at the individual context. Alice talked somewhat about the absconding, how absconding is seen within different states. This tool very much looks at the case factors, how long someone has been in a country, the connections they have, and trying to make an informed decision around whether there is a flight risk. And lastly, looking at vulnerability. And there's 4 types of vulnerability that we found. I mean, researchers generally found that anyone who is placed in detention is made vulnerable. So in effect, everyone in detention is vulnerable. But these 4 categories, no, next one. Next one, that's one. See, my Hebrew is very good. These 4 categories really just give some sense of populations to be mindful of. I've mentioned some of them around age, also gender and diversity, health, and the protection needs of people that may be in detention. And I know Sweden will talk about some of those categories as well. But the fundamental for governments, if you is if we don't detain someone, how do we manage them? How do we ensure they're not going to cause problems, disappear? How do we return them? Because governments assume in detention there is an absolute control, when in fact I'll be talking a bit later around how even the use of detention doesn't guarantee someone is returned. But in fact there are many mechanisms states can use to effectively manage someone in the community. So the community setting, there's a number of factors that we look at. There's 2 different elements that we found. States that have effective programs to manage large numbers, because as Alice said, no state can detain every irregular migrant. It's not possible. So the amount of money that's spent on detention infrastructure, which is billions of dollars in many countries, my own as well, could also be invested in community models to manage larger numbers of people effectively. So some of the ways states do this is the way people are housed, the way they're supported, and then the way they're managed in those systems. So firstly is the living arrangements. There's different models around the world. So if you look at New Zealand and Europe, much of Europe, there is often open accommodation, sometimes called reception centres, where people can freely come and go. They're usually located in an urban situation, so people can access community connections and other needs. Often it could either be dormitory style, shared kitchen facilities, or private quarters for families or individuals. It depends. There's many examples I could give, but often a lot of the support needs are provided to people in that arrangement. In some of the Anglo countries, like Australia, the US and the UK, they don't generally have grouped reception facilities. They often use community groups. People are in individual private rental accommodation or living with relatives. Or sometimes if they have specialist needs, they might be in a group shared home. So a lot of countries, and examples we found were specialist housing for trafficking victims, for unaccompanied minors, for other victims of crime and so on. So there was varying examples of housing, but I think what was interesting was the rights linked to where they live. And again, that looks very different. So in Hong Kong, for example, a person who is living in the community would have access not to cash welfare money, but the government funds an NGO to give the asylum seeker food, clothing, medicine, and somewhere to sleep. So they're actually able to live, but they're not actually given cash. We heard in Belgium yesterday, and we'll hear about that later, they would do the same, but they would have like a small allowance as well on top of that. Other countries will give work rights to asylum seekers, and that also looks different in different places. So, for example, in Canada, Norway, an asylum seeker may have automatic right to asylum, automatic right to work rights if they have some lawful status. Other parts of Europe, it will really depend on their circumstance and the time in the process. So in Spain, there's a combination. You would be in a reception centre, open reception centre, with freedom of movement while you're waiting for a decision. If no decision for 6 months, you would then get work rights. And that's a similar case for the Netherlands, although the Netherlands will put a limit on how many weeks per year they can work, which I think is around 28 weeks per year, half the year they can work full time. So it looks quite different in different places. The US as well, after 150 days, an asylum seeker can have access to work rights. The next question is then where people can reside in terms of those rights. Some countries, and I'm thinking of course of the situation here in South Tel Aviv, for example, other cities and countries have similar challenges of certain locations where asylum seekers congregate and live, and some places will link rights to various locations. So in other words, places like New Zealand and I think we're going to hear from Sweden, will have their reception centres in different parts of the country as a way of providing supports, but also that people can live throughout the community and not just in one place. The other aspect I wanted to focus on is how states manage those cases. What we heard and what Alice mentioned in the research is that asylum seekers very much have been found to be low risk to abscond if they're awaiting a decision in their case, and that governments can effectively implement alternatives to encourage and support people to further be able to comply, and that is very much around ensuring their basic needs are met and they're not destitute, and that they can have information and advice on their case, they can build a trust and rapport with the authorities, and to explore their long-term options. So I just want to focus on this for a little bit. This is very much part of what our research has found is called case resolution. Because as I said, if a state is not going to put someone in detention, they want to know how they can ensure the case is resolved effectively. And case management is a technique many governments are increasingly using, my government included. And it's a way for people, asylum seekers, irregular migrants, can be supported through the process. They can have information about what options are available to them. It can help the authorities understand the case more to determine barriers or risks or elements of their case they may not have been aware of. But it's very much, from a psychosocial perspective, it's around how you walk with someone and support them to look at all of their options. I have worked personally as a case manager. I was trained in Sweden at the Swedish Migration Board, my first job out of university back in '96, and that was very much around how to identify the risks and needs of an individual that's seeking asylum. Since then, I've worked in various countries, and part of what our research tried to do was look at how some of these programs were very effective, and they were very effective both for cases that had to go home, the voluntary return rates, but also for those that had permission to stay, helping them to integrate into the community. So we were looking at some of the strategies that case management programs used. And in some cases, it was very much around supporting people who had no right to remain on the territory. Now, I should just put a caveat here that the programs we looked at had very strong asylum and refugee status determination systems to ensure that people's protection needs, including non-refugee protection needs, are met. And that's really fundamental in sitting down and working with someone to look at return. But some of the strategies used were very much around building that rapport, trying to explore all options for the person. In some cases, there may be new country information the authorities weren't aware of. There may be relatives in other countries, there may be other third country options at the individual level that could be explored, through to starting to look at the issue of return. And again, I'm talking about cases where there is no protection needs. But part of what our research found, and I guess is the case very much here in Israel, is that no country is always effective at being able to return all cases that have had a refusal. It's a challenge for all countries. And there is a number of countries we've looked at, Australia and the UK being one, where 1/3 of all the people put in detention cannot be returned. So that means, you know, thousands of people are being detained for prolonged periods that cannot be returned at all. And in fact, a new study that just came out of Italy, which correlates to a Dutch study and a UK study, showed that the longer you detain someone, there is no correlation to increased return outcomes. So in other words, the use of detention in that case for up to 18 months is not increasing the return outcome. You're generally returned within 45 days or you're not. That's the Italian finding. Now the reason some people can't be can't be returned or are unreturnable really depends on the individual. But there were many examples that we found, everything from some of the challenges in terms of diplomatic relations and being able to access re-entry permits, passports and so on, through to non-refugee protection needs, people that have perhaps are or became stateless, or who have protection needs that are based on torture, through to humanitarian or health crises and so on. I worked with a case in Australia of an asylum seeker who had a removal date. She was meant to go back. The ticket was there. Everything was lined up, and she fell into a coma. And she was in a coma, and then when she did come out of the coma, she was unfit to travel. So she wasn't going anywhere, and no airline would put her on a plane. So there were cases like that we've came across that, you know, they simply cannot be returned. So the question is, what are states doing about those cases? How are they managing them? In various ways. We're seeing that some states are putting in place different types of status or protections, temporary or permanent, to ensure a case is resolved and they're not languishing in detention or lost in the community. So we've seen examples from, you know, Sweden to Norway and the Netherlands, the new Dutch law, the new Turkish law, which have complementary protection systems in law, which mean that they're for those that maybe are not a refugee, but still have a protection need, perhaps around the International Convention against ICCPR. Sorry, I'm getting jet lag suddenly. And the Convention Against Torture, for example, Statelessness Convention. The protections for those groups can be achieved through a subsidiary or a complementary protection status. And also that for those that maybe don't have protection needs, but still cannot be returned, such as the case I mentioned. For example, the Netherlands have a special residency permit, so that someone can still reside in the community with work rights, with access to basic welfare, no risk to being redetained, and that's another option. My country, Australia, is interesting. I mean, we have two very separate asylum systems, and the one you would hear about, of course, is the harsh system we have for people who arrive by boat and who are sent to offshore islands, which very much is because we are an island, we have no fence. So the government has in fact used these offshore islands like a fence for people who arrive by boat. But over the last 20 years, the majority of asylum seekers are not arriving by boat, they're seeking asylum in Australia, and they are not detained generally. And the government has created the government discovered so many cases they could not return. So many cases, and people were either being stuck in detention or lost in the community. So some of the examples, the Australian government, yes, has resolved those cases. In 2012, the government introduced a new complementary protection system that covered CAT and statelessness claims. It also included 2 trafficking visas, a temporary and a permanent visa status. Thirdly, for people that cannot be removed and maybe not having protection needs, they created a special visa, and the visa is called the Removal Pending Bridging Visa. It gives work rights, it gives access to welfare, but it says that so they can have full liberty and rights, but the welfare would be 89% of a national, not 100% of a national, as well as some other work rights and status. So Australia has worked quite hard in the last 7 years to resolve cases. It's been a big focus. I ran a program that I won't have time to go into, but it was very successful. The government decided to pilot what to do with these cases that cannot be returned. They didn't know what to do with them. There were about 1,000 people in the pilot. The majority had spent 6 years lost in the community, with very limited connections and support. And the model was, okay, they need to have information. They need to know that there are a review of their case, a case manager, legal advice, and if there's no new case options, they need to have some voluntary return support. And you can see there's very successful outcomes of that program. Around 50% of people did get some of those status I mentioned, so they could not be returned. The other 50% of the other 50%, we saw a very low level of absconding. They didn't abscond, they maintained contact, and around 60% voluntarily returned. Now that pilot is now a national program used throughout Australia. So I'm running out of time, but I just wanted to highlight, if you just go back to the CAT model. So our research basically found that governments that put those types of systems in place that I mentioned, case management, legal advice, information, basic needs, which are cheaper than detention, up to 80% cheaper than detention, can be very effective. You can actually manage larger numbers, it's more humane, and you can achieve the outcome the government decides, which is to resolve a case. But if a government still has concerns, they can apply conditions on people in the community. And we found there's around 14 different types of conditions placed, which we've grouped into these categories. The requirement on an individual or the requirement on the authorities to supervise an individual case, or some other requirements such as bail or bond placed on an individual. Now I know here in Israel the discussion has been one of reporting. Reporting to the authorities is used in many countries, and it really looks different in every country. Australia to Greece, for example, the reporting is generally once a week to once a month. Some countries is more, but it should always be individually assessed that there is a need to actually report, and also that it's reviewable. And we'll hear later, I think, from the US, some other ways that they are using telephonic, like telephone reporting, so people actually don't need to go in to the office, they can just have a voice recognized reporting. But a lot of countries don't put any conditions at all of this type, but they may have a requirement that a person attends their hearing. They have to have contact with their caseworker. That seems to be the default. And one of the reasons for this, and our research found, there is no correlation to high levels of conditions on an asylum seeker with high levels of compliance requirements. So in other words, the more you put a requirement on someone doesn't increase the likelihood that they will keep in contact with the authorities. In fact, sometimes if you put too many reporting requirements, you set people up to fail, and they disengage from the process because they can't maintain every requirement on them. What tends to work is the opposite, what I mentioned before, the case management and the legal and information advice. So just in conclusion,
Just key findings. Three of them.
and Alice mentioned some of these, I think the key takeaway is that there's a number of things states can do to ensure detention is only ever a last resort, that you can actually manage these issues in the community. But as I mentioned, I think it takes a commitment from the authorities to move away some of the investment in just detention into some of these community models. The ways governments are doing these is very different. Some countries will create legislation. Some countries will develop policies or working groups to explore how to implement alternatives. But the main one we've noticed a lot is pilots, like the Australian pilot that I was a part of. The Belgium model we'll hear shortly, and also the US model we'll hear. So I think there's a lot to learn for Israel from some of these examples, and I just want to thank you all for your time today. Thank you.
תודה לגרנט באמת על הדוגמאות הפרקטיות ועל הלקחים שנלמדו ממדינות שונות בעולם. הערה טכנית, לפני שאנחנו ממשיכים, אנחנו קצת באילוצים של זמן, אנחנו נמשיך באופן ישיר לדובר הבא, מבלי לקחת שאלות כרגע, כדי שלא נעכב אותו. לאחר מכן אנחנו נמהר עוד יותר לראיון בסקייפ, מחכים לנו בארצות הברית, לראיון נוסף, ולאחר מכן, אני מבטיחה שאנחנו ניקח שאלות, יהיה מספיק זמן לדוברים, למומחים שיוכלו להשיב, אז תרשמו לעצמכם הערות, תגובות, שאלות, כי אנחנו נרכז את הכל אחר כך בפאנל בחלק האחרון. בזמן שאני מדברת, תוכלו להתחבר לפרזנטציה הבאה. לא מגיע?